gives me a great pleasure to introduce George Kaelin from the firm of the Ask Law Group, stand for Allen, Semmelsberger, and Kaelin. Some of you recall that a few years ago, David Semmelsberger came and addressed our group in Seattle after they had won a $111 million judgment from an ELS community case in San Jose. It was a California-Hawaiian case, but before the Ask Law Group, it was known as Lincoln Turek and Heater. It's based in San Diego, but they have a long storied reputation of success and especially failure to maintain lawsuits in California. And it's really interesting setting up meetings at some of these communities to have one of the attorneys from the firm to come out and speak at a community. One in particular in Carlsbad, California, a coastal community, but after it was noticed to the residents that there was going to be a meeting and one of the attorneys come up, and there were several different types of maintenance issues, but it was just amazing that the repairs that were being made by the park owner, trying to spruce things up and make the clubhouse look a lot more presentable, and trying to appease these homeowners, say, oh yeah, we're putting money back into the park, and trying to take away some of the arguments of the homeowners, and that they know what the attorneys use as solid arguments. And we really appreciate that George would come over. Deanna, do you have a comment?
I just want to add something on that same point. ELS had a big district-wide meeting at our park a few months ago. And leading up to it, of course, we as residents didn't know they were having a big ELS meeting, but all of a sudden a street cleaner comes through, and the landscaping guys are out doing all kinds of stuff. And we noticed, they're painting the yellow curbs a little more, and we were like, wow, what's going on? All of a sudden it was like, clubhouse will be closed such and such a day for a private ELS meeting. We're like, oh.
That's fine.
Yeah.
The flowers are dead, by the way.
Right. Well,
yeah, right, and all kinds of new flower pots. Oh yeah, it was a beautiful showpiece.
Yeah. Well, there has been a little different mindset by ELS in some cases, and part of that reason is because we have had a heavy hammer in California, and as we mentioned, our mobile home residency law, our state civil code, and our Title 25 or the Mobile Home Parks Act that deals with health and safety codes. They're civil laws.
So we
they don't
thank
have
you.
that criminal side. And so we're very lucky to have some firms that understand the intricacies of manufactured housing law and are large enough firms that they can withstand the long, drawn-out, expensive process of taking these community owners to court. And at this time, as I mentioned, please join me in welcoming George Kaelin.
You gotta turn it up. Flip it on. Sorry.
Is it on now?
Yeah.
I keep debating whether I should use a microphone or not. So I'll start with a microphone, and I might start yelling, getting my voice out there. Yeah. Thank you very much, Tim. So our firm thanks the world of Tim, and Tim does an incredible job in California now, throughout the country. It looks like advocating on the issues that are most important to manufactured home community owners, and so I'd like to give a round of applause to Tim. It really makes our job a lot easier when we come in to a situation when people are organized and they have a unified voice. It really helps us to take on their case. So real quick, I just want to get a sense of who's here and kind of what everyone's experiences are. So how many people have heard of our law firm? So about half, or a little over half. How many people live in ELS communities? Samzel. Everybody's on the left side of the room.
We're unifying.
You're unifying. You guys have a lot to talk about over there, I guess. How many people have actually been involved in lawsuits as owners of your homes? Okay. Mostly the Samzel.
Ready?
And then how many people are legislatively active? How many people are actually, we should see every hand, but, which is what I'm going to talk about. And I was listening to some of the other folks that got up here and talked, and people were talking about the attorney generals, getting the laws and then getting the attorney generals to go after the park owners to protect everyone's rights. And unfortunately in California, our attorney general, we have a very large state, the attorney general doesn't necessarily get involved in mobile home issues. And so that's where private firms like ours, we've focused almost exclusively on enforcing mobile home owners' rights, manufactured community owners' rights, and that's how we make our living. That's what we've been doing. So what I want to do today is kind of talk about what we look for, what laws are important to have in your various states that can give us the ability to come in and protect you if you cannot get the attorney general. So does that sound fair?
Yeah.
So first of all, I'm going to go over the handout so everyone understands what everything is that's in the packet. So did everybody get one of these at your table? It's going to be important to take this with you. So in your package, you're going to have a couple of things. One, you're going to have about a 10-page, 15-page, very, very detailed explanation of the laws in California mainly. And it lays out specifically a lot of the laws we pioneered in suing different park owners. And so if you don't need to go through that now, but just know that you have that as a resource. So maybe if you're traveling back home, you want to kind of read through and kind of see what in detail are the laws that we focus on. We also have a bio of all the lawyers that are with our firm, and without exception, every single lawyer in our firm is focused on mobile home owner issues for the majority of their career. We also have a questionnaire, and that questionnaire is kind of what we hand out to when we go out to manufactured home communities. This is a questionnaire that we hand out to get an idea on some of the maintenance issues. So a lot of our cases, and I'll talk about that, maintenance of the park and the ability to provide and maintain the common areas and the facilities, it's a key to some of the stuff that we do. So I'll talk a little bit more about that. And then we just have some, I think, which is probably the most entertaining, is we have a compilation of all of our newspaper articles. Our firm has won over $250 million in judgments against park owners. One of the things that we found that park owners really like is the money, so we tend to take that away from them. And so we've, on behalf of, I think we've represented probably 7,000 mobile homeowners over the years, and we've been able to secure verdicts of over $250 million, and keep those. And actually keep those on appeal. If you count the ones that we've gotten big jury verdicts and the Court of Appeals or whoever's come and knocked them down, then we're in the $500, $600, $700 million range. So that's if you read through, you can kind of read some of the cases and some of the fact patterns that we focus on. So yeah, our law firm, I'll give a little bit more background. So our law firm started as Endeman, Lincoln, Turk, and Heater. So I don't know if you guys recognize that name. Endeman, Lincoln, Turk, and Heater Elk Law. We started 30 years ago, and we were formed specifically to go after mobile home park issues. And we all left a larger firm. I wasn't with them at the time. I was actually with the larger firm. And there was this mobile home case, Lake Jennings. And a couple of the partners in the larger firm are like, gosh, what's happening out there is horrible. How these people are being treated. This park owner, he was retaliating. And so a couple of the attorneys, or the partners at the large law firm, said, we really want to take this case. And a lot of the other lawyers said, nah, mobile home law, it's not really what we want our firm to do. And so Endeman, Lincoln, Turk, and Heater all said, well, we really like this case, and we really think that this is an area of law that is underrepresented. So they actually broke off of the large firm, had the big offices, the cushy jobs, and they said, no, this is something we really want to do. And so they broke off and sued the owners of Lake Jennings Mobile Home Park in San Diego, California, and they got a $7 million verdict. And it was upheld by the trial court, upheld on appeal, and it was collected. The next thing you knew, we were getting calls from all over the state. We've got those same problems, we've got problems, we've got problems. And so that's how our practice was built. Everyone initially thought, well, there's only so many mobile home parks in California, so we'll probably be doing this for 10 years or 15 years, and we'll get through. We're going to clean everything up. 30 years later, we're still doing it. In fact, in some cases, we've gone and we've sued the same park 2-3 times. It's just, park owners do not learn. They just, or what they do is they don't maintain their parks, and they create a lot of ill will in their parks, and then they sell it to somebody else.
Yeah, that's nice.
And then that person comes into the situation, and then they end up, having to try to bail out, and they're not necessarily, they don't necessarily do the right thing, and then they end up getting sued. So our firm has been doing this for a long time, and we first, one of the other areas that we first got into was rent control. So Escondido, California was one of the first cities in the country to pass rent control. And there was a big case called D versus the city of Escondido that went up to the United States Supreme Court, specifically on whether rent control was legal, or whether it was constitutional. The park owners made the point, or the argument, that it was taking away their property, it was taking away their ability to make a fair return on their property. And so Don Lincoln from our law firm represented the city of Escondido up in front of the U.S. Supreme Court, which ultimately we prevailed and upheld rent control. Since then, we've represented just about every city in California that has rent control, because what's happened as you all know, in the mobile home industry, especially in California, we've gone from the mom and pop owners to the corporate owners, right? And the corporate owners are very sophisticated. They hire economists, and so they go after the cities on fair return and all the different issues. And so what ultimately happens is when the rent control board gives an increase that's not sufficient in the eyes of the park owner, they sue the city. They sue the cities, and so then the cities have to hire our firm to defend the decision on rent control. And so we have our battery of economists as well. And so that's been, unfortunately, the park owners have been wearing down the cities, and the cities have been, they pay our bills, and we give them good rates, but still, it's, they're getting tired of paying and taking the brunt to uphold rent control. So, but that's another area of our practice. Unfortunately, that area has gone down a little bit as some cities have gotten out of the rent control business, or have been more amenable to the park owners and giving larger rents. Yes?
So if you had rent control, rent fairness, rent stabilization, whatever you want to call it, at the state level, would that make it easier, obviously, for the cities to be stronger in their defenses against?
So the question was, if there was rent control at the state level, would that be better? Instead of having all the cities have their individual rent control ordinances, it would. It's just very difficult. I think there's a couple of states that have laws specifically on. Delaware has a good law, and the Attorney General just sued. Yep. And then you've got Florida has a great. Florida has. So when we get ready and we go to battle, and I'll talk about a couple of cases that show how practical this is. We look at Florida's laws, or we look at Delaware's laws, and we're like, man, if we had those, it would make it a lot easier for us. So the answer to your question is yes. It would be better, but it's difficult to get at the state level.
In New Jersey, we looked at that question quite a bit as to whether or not to push for a state-based rent stabilization law, and after some careful
you know, there's two different thoughts there, right? From my standpoint as a lawyer, it's better to have a state level law, because if you don't, you have the individual cities passing rent control, right? And you have those battles that I'm talking about. And what we're finding is less and less cities are taking on those battles. And so what happens is, we've got, and what we're facing is, there's 3 or 4 owners. There's obviously there's ELS, we've got Court and Scott, we've got Tatum and Kaplan, which are more of this corporate model of ownership where they own 15, 20 parks. And so what we're finding is, they're coming in and they're finding out that pain threshold on rent, right? And so they're upping it and upping it, and they have these different provisions that, you know, that trick people, and they just push that envelope. So basically they suck any value that you have in your home out because they push that rent up so high. So what I'm talking about on a state level of some sort of law regarding rents is, to give you an example, we just, and I'll talk about it, it's called Terrace View Mobile Home Park. Our firm just got a $60 million verdict against a park owner on behalf of 10 homes. You can do the math, it's pretty good. So we got $6 million per space or per home. And in that case, it was a battle, because this park owner had wanted to redevelop the park. There was a lot of multifamily housing and various developments going on around the park. And so they ultimately wanted to close it, but they didn't want to go through the closure process and pay relocation. So what they started to do is implement these just draconian provisions in these leases and just start upping rents. And one of them was called a catch-up provision, which is the rent would go, after 3 years of the lease, the rent would go to the highest of the three rents in the park. So you could sign on at $1,200 a month, and after you've been there 2 to 3 years, it goes up to $2,000 a month or $2,500 a month. And so people were getting hammered, and the park owner would then go to the people and say, well, I'll do an emergency rent stabilization, the park owner caused, and have people waive all their rights under the mobile home residency law. And it was like a plane crash out at that park, and Tim was instrumental in helping us out, and that was called Terrace View Mobile Home Park. But we're coming back full circle to the question, as we're sitting there looking at this case, the law on regulation of rents, if you don't have rent control, is very difficult. It's especially in California, it's unless you get to a point where the rent that is charged is a constructive eviction. So if a park owner raises your rent to $20,000 a month, well, obviously they're not offering you a lease, and so they're constructively evicting you. So and this park owner is a lawyer, and he was very, very careful about just riding right on that edge. He was just inflicting pain on everybody, but not quite just making it where he was charging $20,000 a month. He was charging 40, 50% increases, and 30% increases, 20% increases, and ultimately he got up to a point where there was a pain threshold, but then he would offer the emergency rent stabilization. So back to the point, we were looking at the judge in the case said, well, why don't you guys brief these issues for me? Give me paperwork on kind of what can a park owner do, what can't they do, and looking at it, we had looked at the laws in Florida. I don't know if I'm pointing to the wrong table because you said you're New Jersey. Florida has a law that says a park owner can only charge reasonable increases, or something along those lines. And so if we had that, and we got to go to a jury on, hey, is this guy, are these leasing practices, are they reasonable?
Right.
We would have creamed them, right? It would have been over. So to your point about having some sort of national, some sort of state level law, it was helpful. In Delaware, you've got, I think it's CPI.
CPIU, 3-year average.
Right. So obviously his rents were higher than that. So it would have been helpful to us to have a state level. Does that answer your question?
Yeah, it does, and I appreciate that very much. And I get that it's difficult to get to the state level, but I'm just curious why all of the jurisdictions, and there's about at least 100 of them in California, why you don't have the lobbyists from those jurisdictions pushing along with the homeowner advocates to get into the state level, so they're not having to constantly battle against BLM.
And that would be a question more for Tim, quite frankly, because what we do is, I mean, we go and speak at you know, legislative forums, and we try to do what we can, but we're not, you know, we've got our hands full suing park owners with the laws that we have. So yeah, so that would be a question more.
And we have tried it in the past, and I'm sure it's evidence. The community owners have a strong lobby. It's a lot easier to kill their bad bills than to get the good stuff passed, like enforcement bills or whatever.
Right.
But
So-
our arguments are getting more compelling.
So in terms of our law firm, after rent control, we really focused on a lot of failure to maintain lawsuits, which in California, we have a really good law, which says that a park owner must maintain a park in a good operating condition.
Healthy condition.
I'm sorry?
Healthy condition.
Healthy, good. Well, for us, good operating is better. Good operating, because if utilities start to fail and they're not operating in a good condition, we can go in front of a jury and say, hey, they're having sewer backups. Hey, they're having electrical outages. Hey, they're having water outages. Is that a good operating condition? The other aspect of it is in California, and it's in the packet as well, is we have a law that says if a park owner doesn't maintain a park in a good operating condition, it is a public nuisance as a matter of law. If you don't keep your mobile home park and all the or manufactured home community and all the common areas and facilities in a good operating condition, it is deemed a public nuisance as a matter of law. And so we won on that theory with ELS. Okay. And not only do you have to maintain, but you have to provide and maintain.
Continue to maintain.
Provide and maintain. Provide is key, because what happens, remember what I was talking about with the rents, and ELS plays games with rents, is having that law is so key, because if they can play game with rents, we can play games with provide and maintain, right? So like ELS, they took over a community, I'm sure you guys have already seen this movie, but they start upping rents and they start lowering the services. And so next thing you know, the clubhouse isn't open as much. The pool is closed more. You know, the whatever amenities they have, they'll just start closing them down, or they'll restrict them, right? And so that's what we use as lawyers, is we come back and say, okay, well, it's hard for us really to on the rent issues as I just discussed, but you know what? You got to provide and maintain all these facilities, and you're upping rents and you're not providing and maintaining. So we're not getting the benefit of our bargain, okay? And so that's what we went to, the Cal Hawaiian case. We sued ELS up in San Jose, and when we first got the case, we're like, man, you know, this isn't really, typically we have cases with sewage coming up in the bathtubs, and we've got electrical lines falling, but here you've got, you know, it's more subtle the way they do it, right? It's just kind of like, it's more like water torture. They start cutting things out, and so what we did in the Cal Hawaiian case is we put their business model on trial. And we were able to find that they paid bonuses to their employees and to their managers or district managers if they lowered their operating costs.
Really?
So, yeah.
Yes, they did. Of course, yes, they did.
So they had a specific bonus structure. So if you could cut the operating budget down by 25% and increase the rents, then the profit that they were going to go back to their Wall Street, you know, investment bankers and their stock prices were going to go up, right? And so we were able to put that on trial, and the jury just hammered them, absolutely hammered them. So the jury awarded $111 million. 111.
What's the outcome now?
Okay.
This day?
Yeah. So.
Yeah.
What's the outcome of the?
So yeah. So what happened was the park ELS filed motions with the judge and said, you know what, Judge, these verdicts are too high.
Yeah.
And
We can't possibly.
yeah. And what's funny, not funny, but so what happens is, in San Jose and in the courthouse, it's somewhat conservative, even though you've got some liberal areas around there. And so all of a sudden you got a $111 million verdict. And it's the biggest verdict they've seen in that courthouse in a very long time.
Yeah.
And so when the jury first announced its punitive damages, which I think 90 million or 80 something million of that 111 was punitive to punish them for their oppressive and horrible conduct, after, when the verdict came in, ELS said, hey, can you seal that? We don't want that public. Can you put that in an envelope? Yeah, we don't want anybody to know. We don't want anybody to know. And the judge looked at him and said, this verdict is a message, or this jury is sending you a message about the way you do business. Yeah. And so the judge said, I'm not going to seal anything. And so it got recorded, and there were newspaper articles on it and whatnot. And so at that point, the judge seemed to be, pretty supportive of a large verdict number in that action. As time went on, we heard stories about some of the other judges in that courthouse. Hey, what happened? Your jury got out of control. You lost, basically, Judge, you lost control of your courtroom.
Oh,
really?
And this was her very first jury trial. This judge, it was her very first jury trial, and she's got a jury awarding $111 million. And so ELS made a bunch of motions, and the court granted a new trial on all damages.
wow.
Yeah, so a new trial was granted on all damages. It was,
It's devastating.
We're up on appeal right now. We have, what the judge did is the judge changed the legal theory after the jury gave their verdict. Okay, so if you're living in an ELS community, right, it is like water torture, and you live through it day in and day out, and it's just a struggle. It's a struggle. And so the jury got that, and the jury awarded our folks two elements of damages. One was emotional distress, like emotionally what it's like going through living in that park or in those communities.
Right.
Your peace of mind is just, it's gone because you're constantly dealing with these issues. And then you get overpayment of rent because they're not providing and maintaining, right? And then they got punitive damages. The judge came along and said, well, and ELS argued, well, in order to get emotional distress damages, the impact on the living conditions have to be to a point where no reasonable person could endure them. And these people are enduring it. They're still living there. They're not moving out. So therefore, the plaintiffs didn't prove this amount of damages. And when they filed that brief, we're like, oh. When they filed that motion, we're like, oh, we're going to win for sure. That's the stupidest argument. You can't be. It's just, you can't try a case to a jury on one theory, get an award, and then just completely change what the rules are, right? Yeah. And plus, the law, that's not what the law says. But the judge, we believe, got a lot of pressure from the other judges. So she bought that argument and said, you know what, you guys got to do a new trial, and the standard is going to be, these folks have to have lived through something that nobody could endure, which by definition is, you can't, right. So we think we have a good argument on appeal, so we're up on appeal to say, wait a second, appellate court, give us this verdict back, and so that's part of where we're at. The other thing the judge ruled was on punitive damages. The judge ruled that we did prove liability for punitive damages. So that ELS's conduct was oppressive, fraudulent, all the bad stuff you can imagine. And so they've appealed that. They're saying, no, we're not that bad.
They love that too.
Right. And so they appealed that. So we appealed saying we want our damages back. They appealed saying, well, when we go back and retry this, we don't want to have a jury finding already established that we acted with for punitive damages. So that so because right now the way it's set, if the appellate court does nothing and just says, I affirm what the trial court did, then we're going to go back and we're going to try it again, and we're going to try it with the judge telling the jury there's been a trial on this case already, and there's liability for failure to maintain, and there's punitive liability. These folks have acted with malice, oppression, and fraud, and so you're entitled to give them punitive damages. So and we're not shy to take another swing, but ELS has reached out to us and wants to try to settle the case, and it's interesting. So we went up to San Francisco a couple months ago, and they've had a change in some of their senior management, and so the one guy who was there, Jeff something, he said, can I talk to your clients because I want to apologize for what's happened. And so he came in and they expressed to us that they kind of want to start doing things differently, and not significantly, but in the baby steps. So we're getting their attention, and what I was telling Tim before is we've sued them a lot. I think we've sued them 4 or 5 times, because they thought, okay, well, this is a small law firm and we're just going to grind them into the ground. We grind everybody into the ground. And so, our firm, we keep $1 million war chest to go after these cases. And so we've gone toe to toe with them, and they used to not tender their cases to insurance, and they just want to fight it out with us in the trenches. But they've indicated now that they want to start trying to resolve cases and make some repairs and change some of the practices, reduce some of the rents, and so we'll see. And that's what they said, but they haven't actually done it. Yeah.
Can I just ask a question? So in the part where you got that verdict for $111 million, has anything improved just as a result of that verdict?
They have made some improvements. Obviously, as soon as we file a suit or as soon as we send a letter, then cosmetically they go out and all of a sudden new flowers.
Yep. Yeah, we know that.
There's paint over the dry rot, right? So, but they've done some other things. They put in some additional water valves. They've done some, they've done work on the electrical system. But that was all under the order of the judge. So the judge was kind of overseeing both our electrical expert, and their electrical expert went out and they had to come up with a repair plan. Yes?
I have 2 questions because they'll tie together. I'm from the state of Arizona, and in Arizona, ELS has over 9 properties. But we have a hearing system that's allowed for the residents to go through and give their concerns. And we're being told now that since there's so many different parks involved, that we should skip that hearing process and go to Superior Court against ELS with all of the parks that are involved with their issues and concerns. And so I guess my first question is, should we get the hearing process that have a decision and then take it higher, or just skip the hearing process and go right to the top? Because there are parks that have the monies to do this. They have their own little organizations, but to the tune of $15,000 that we've got a lawyer right now that they would put out to take them on.
And do you want to come to Arizona?
Yeah.
That's the question, right, Bill?
Well, that's, interestingly, that's, and I don't want to focus just on ELS. I know ELS is a big issue, and I know there's some people that aren't ELS, so I'm going to get off of ELS in a little bit.
And I guess that was my second part.
Yeah.
So there is so much going on nationwide against this organization. This
right. So to answer your question, I can't just give you an off-the-cuff answer because there's a lot of different complexity to what you're saying. I think, and I don't know anything about that hearing process or what happens, but if you bypass it, what's going to happen when you sue them and you're on the stand? Their lawyer is going to say, well, you're complaining about A, B, C, and D. Well,
Right.
didn't you have an opportunity? Doesn't your state give you an opportunity to address that? And you didn't do that. Instead, you came in here and asked these jurors for money, and so they can twist that on you very, very effectively. So that's why I'd be very, what I would do is, and I'm kind of going through, kind of pulling some stuff up from the back, but this relates to everybody, is get the numbers together, right? If there's other parks that have these same issues, and you guys are organized, they're organized, get everybody together, give our firm a call, and we can come take a look at it, and hopefully give you some advice on how to navigate those waters and put yourself in the best position, okay? But just in general, whenever you're going against mobile home park or manufactured home community owners, the more organized you are, the better. The larger the number of people, the better, right? And ELS tries to fragment you, and park owners all over try to fragment you and scare different, scare folks. And so if you can stick together, then and get evidence. So if there's issues, take photos of them. Take photos of the situation. So document. Keep logs. That's the best thing that you can do. And give us a call. And we are looking at potentially going and partnering with law firms in other states that but the laws that are important to us are some of the laws that I'm talking about, and like the provide and maintain law, and you'll see them in the handouts. Another one is attorney's fees, having an attorney's fees provision. Every single law in every state that relates to mobile homeowner rights should have a provision in the law that says if the owners or the residents have to bring a suit to enforce their rights, that the prevailing party is entitled to attorney's fees, because that enables my firm to come in, and if there's a case that the damages aren't very high, we can still come in and help, and then we're basically betting on the fact that we're going to win, and we're going to be able to go and get our attorney's fees from the park owner. So that's another key legislation. Yes.
Have you had any issues with Sun communities in California?
I'm not familiar with them.
They're the second
Yeah,
largest.
we haven't.
They're the second largest community developer owner in the nation.
Yeah, they haven't come on our radar.
I'm just confused. I live in a Sun community, and when it was my turn to stand up there and speak, it's difficult. I understand what everybody in this room is here for, but I don't see that same issue with Sun communities, and they're the second largest community owner in the nation. I've watched their return on investments for their investors, their quarterly dividends and their quarterly profits. They're almost neck and neck, side by side with ELS. But yet, in the state of Florida, which I'm most familiar with, that's why I was asking you about California, they don't seem to have these conflicts of over-aggressive greed that ELS and Santel have.
Right. Well, you're lucky. I mean,
they don't train their managers to be.
Yeah. I mean, so, which I think goes to the point of you can run your communities properly and not have those issues. It's just certain, ELS is a very special situation because Sam Zell his nickname is the Grave Dancer. So he doesn't necessarily focus on business for a win-win. He really wants to just. So it has not come across our. They have not come across our.
They're based out of Southfield, Michigan.
Yes.
They're a publicly traded company, and they're doing very, very well. And it's difficult to say anything bad about it.
Right. Well, and you're lucky, and that those are the type of owners that would put us out of business because we don't really have anything to come in and help you. Right. So,
Can I say something?
Hold on, real quick. Do you have a question?
Quick questions. One is there some kind of a network of attorneys or work group or listserv or something, a attorneys who work in this area of the law where, you know, people can discuss issues or perhaps have some kind of a communication? That was one question. The other question is, if you've got all this multi-state stuff, do they make clear federal provisions that might be addressed, like in criminal activity?
There's some, yeah, if you look at your handout, protecting the homeowners, there's some limited federal, but that mainly deals with the codes on manufactured homes and certain standards that they have to home themselves.
Fair housing law to these kind of practices and say that these kind of practices violate.
We haven't. And what I'm going to do, and as I move forward, is, and Tim had asked me to cover was, you know, obviously in California we have certain laws, and if you can get those same laws in your states, that'd be great. But if not, there's some common law provisions that we can talk about. So.
And about the network?
I'm sorry, and there really isn't. Just call our office. There isn't. Trust me, it's hard to make a living suing park owners. You have to be well funded. So our firm has to keep $1 million in reserve to go after these guys.
Yeah.
You know, there's a smattering of lawyers that do it, but it's not really. What happens is we'll get a big verdict, and some lawyers will try to get into the field, and then they'll end up not doing very well, and then they'll disappear. But there are a couple that are out there. I know there's one in Ohio that's pretty good, and Tim knows him, named George Cochran, and he does it. But I would talk to actually Tim about if there's other lawyers that he knows.
There's something that depending on the demographics of your communities is important that we found, and that is you go to community legal aid societies, and they work with a lot of indigent people and different, I don't want to say class of people, but they represent people that can't afford lawyers. And so they're a little more well-versed, we found, than just off-the-street lawyers.
Right, and that's a good point. But and this was part of my presentation, is if you look at the laws in a lot of the states, there's a very low bar for a mobile home park in terms of how they maintain and they operate their park. Most of them have habitability as the standard. So habitability is a very it's a very basic, you know. So in our situations, you know, the park owners they cling to that on the habitability issue, and you know, the bar for them is so low to be able to meet habitability, because really what they're doing is they are renting the space. You own the home, so most of the habitability issues relate to the home that you own, not necessarily the space. And so that's the problem that we run into. The apartment tenants have more habitability issues. They have windows with holes in them. They've got leaky pipes, and there's different things that you know, draft and heat not working, that kind of stuff. So the key is to, and I'm going to come back to his comment. The key is to get that legislation passed that says they have to keep everything in a good operating condition, or it's a nuisance, because that's such a better standard. But this gentleman's point was there are legal aid lawyers out there, and a lot of them will focus on habitability issues. A lot of times the park owner rents the home and the space. There's, and especially like in certain communities, there are, like up in Northern California, there are a couple of communities where the legal aid is actually pretty active in helping folks out. So does that address your point? Okay. Yeah. Hold on a second.
Just real quick, Ed, Green, we got problems with some properties in Arizona. So they are on our radar. Kelly just said that. So you may want to speak with her.
And what happens too is sometimes with the economy, when the economy goes down, sometimes you'll start seeing some problems that pop up. And we find that when the economy's at its worst, our business is the best, because the park owners are putting less into the operation of their parks, and they're trying to pull out more money. So I touched on Terrace View, and I think Terrace View is it's the case we just got the $60 million verdict, and I'm going to talk about that case a little bit more in the context of how as a resident in a mobile home park, if you do have certain issues with the rents that are being charged and the maintenance, and you're not in California, what laws are there out there that can protect you? Right? So, unfortunately, there used to be what are called torts. Does anybody know what a tort is? A tort is a legal theory to protect people. And there's been tort reform, and so most courts in most states have been pulling back on the protections. So does everyone know the McDonald's case?
Coffee?
The coffee. Right. So what's happened after that McDonald's case is woman spilled coffee on in her lap and sued and got a big verdict, and so the insurance industries and a lot of the large business lobbyists really push that hard in public opinion to say, look, things are out of control, right? Things are out of control in terms of people suing to protect their rights, and so you're seeing the slow ratcheting of rights being taken away, right? And so what we're finding is, legislation is the best tool. So if you can fight to get legislation on some of these basic things I've been talking about, it really is your best bet. But that McDonald's case, it's interesting because McDonald's had a memo where they said, look, if we keep the coffee at a certain degree, then it stays good longer and it's more profitable for us. We don't throw it out. Right?
Yeah.
So they made a business decision. Hey, we're gonna put out this scalding hot coffee because it's gonna save us. They had an analysis of it and what it was going to cost them in potential personal injury suits and whatnot. And so that's why they got hit so bad. It wasn't just somebody that, and this woman had third-degree burns,
Yeah.
and she was disfigured, and so
Her skin was falling off her body.
her skin was falling off. And so, but the whole point is it's a battle. It's not just there's a battle out there just on protecting people's rights and protecting people's safety and health and welfare. But Tim did ask me to kind of talk about what can you do outside of the specific laws I've talked about, which is everybody should come out of here with provide and maintain a good operating condition, having an attorney's fees provision. Those are keys, and then also closure laws. I don't know how many people have closure laws in their states, but that's the next wave. You want to make sure you have a good law that prevents you in the case the owner of the manufacturing community decides to close the park.
Just a quick question. We've worked a little bit with your firm. I'm from Port Scott Park in Fountain Valley near Huntington Beach, and we talked with Maria Rippo there, your paralegal. But our issue is we're trying to get the percentage of people to sign up because we do have to maintain a time. And we found that maybe it should be 20% or 30% of the park. We've used some of Paul's numbers to try to see what gets, ask law firms to get involved. And now that you've had a lawsuit with about 10% or 10 people, nearly $60 million lawsuit, we're wondering if you're finding that we do not have to get the super high percentages of people to understand, educate. It's a lot of work, meetings and meetings to get them to sign your, to fill out your form. So is it now easier to get people to fill out the form or ask law firm and get involved than it was before? That's all.
Okay, so a little bit of background on that question. And if you live in a community that doesn't necessarily have the problems that we're talking about, it wouldn't necessarily be germane to you. But our firm, what we do in looking in cases, and it gets back to my point about numbers. We typically, historically, we wanted to have 51% of the residents in a park to join together to sue the park owner. Because I tried a case called Avalon Carson against the park owner. We got a $12 million verdict. And we were packing up our bags after the case and thinking that we'd done just a great job to really whack this guy. And the bailiff comes up to me and says, I knew you guys were going to win on the first day. I'm how did you know we were going to win on the first day? And he said, well, you have so many clients. There's so many residents from this park that banded together. And he said, I know how tough it is to organize people and to get people unified in a situation. So he said, I knew you were going to win because of everyone you had as clients. And so our firm has traditionally required 51% participation in order for us to take a case. Because, and we call it, and we look for fire in the belly. Do people have fire in the belly? And sometimes it's difficult to get folks to have fire in the belly and to unify. So we have, the first exception we made to our 51% rule was ELS. So ELS, what they did is when we started meeting with people, they sent letters out to all the residents saying, look, our park is beautiful, and if you sue us, we're going to take your home.
Wow. Wow. Yeah.
So as soon as that letter went out, we're like, okay, we'll take this one because they got up in front of the jury and they're like, oh, there's only 10% of the residents are suing. I mean, that shows that there's really not a problem. And we put the letter up, and said, you intimidated these people.
Yeah.
And that's part of why they got hit for such large punitive damages, was they intimidated people. But we are, and you had asked about the case for 10 people with $60 million. In that situation, we actually represent 60 people, 60. The judge just wanted us to try 10 people first and go through a trial so that way it didn't clog up his courtroom for 4 months. So he said, look, just try 10, and then let's get a verdict for these 10. But we have other people that we're going to, and that's terrace views, the mobile home park. So we try to get to that 51 number. If there's reasons, especially now, and what I want to touch on is some of the economic issues that are happening that are key. So if you're in a Court and Scott park, and if you've got certain parameters around the way the lease is working, then we will come in and we'll do it for less. We'll do it with less than 51%.
Well, we've had sewage running down 2 streets of our park and all the documentation, paper trail every day. But we have like 10 streets on our park. So the problem is when you have failure to maintain, one part of the park can be down, those people are great, but the rest of the park doesn't even know it, that's involved. So it's very hard to get everyone.
On the maintenance, absolutely. So what you'll do is you'll have one lateral or one area that is a constant problem. They don't come in, they don't repair it, and that has a continual problem. So in that situation, make a point when you talk to our intake person saying, look, we have a specific area in this park that has issues, and they don't necessarily affect other areas. And so, if you let us know that, then we'll focus more on just that section. Okay. And when we do a case, when we do a failure to maintain case, we hire 5 to 6 experts. So we'll hire plumbers that'll go out and they'll put cameras down all the different lines to see what's there. We hire electricians that go through the entire electrical system. We hire appraisers that look at the rent issues, whether or not for what they're providing and maintaining is at a fair rent. We've got water experts that test the water, and so if you have specific areas of your parks that are having problems and others aren't, still give us a call and we can try to address that. But on the terrace view case, and this gets to the laws that you can use to protect yourselves. There's 2 laws out there. There's common law nuisance. Okay, so I talked about a statutory nuisance, failure to maintain a good operating condition. That's under a statute. The law says you have to do that. If you don't, it's a nuisance. If there's no statute on that, there's common law that says that that one has to operate their property in a way that doesn't unreasonably interfere with the use and enjoyment of property. So if you have a situation like you just identified with sewage going down the streets and in your park, obviously that impacts the ability to use and enjoy your property. So we do it doesn't necessarily have to be a statute. There are some laws that in other states, if you have maintenance issues, and those are laid out in the materials as well. And then on the rent issue, in Terrace View, it was a dogfight because the judge, remember I said he asked for all the briefing on whether or not what they could charge for rent, and he just said, you know what, I don't want to set rents in a mobile home park. I don't want to set rents. That's not my job. And so, you know, he initially was very, very, it didn't look good for us. And so we were scrambling trying to figure out, because what this park owner was doing, I already mentioned, was horrible. I mean, just ratcheting up the rents, and half the park was empty. And so we, you know, in looking at it, we ended up settling on a law called good faith and fair dealing. Does anyone know what that means, good faith and fair dealing? What that says is in each of your leases, and it pretty much applies throughout the country, there's an implied covenant of good faith and fair dealing. And throughout the country, it's applied pretty similarly in that you have to have a situation where one of the parties to a contract or a lease has discretion. They can, you know, like for example, in Terrace View, the park owner had the discretion, if someone was selling a home, they could either offer a new lease to the person coming in, or they could require the buyer to keep the existing lease, right? And so what the park owner was doing in that situation was, if someone had a high lease, super high lease, then and someone was trying to sell a home, they'd say, well, I'm going to keep that lease, right? And then the park owner owned a bunch of homes because they were taking homes back from people. So then that same buyer would say, hey, you know what? You want a new lease? We'll give you a new lease on our home. Buy from us, and you can get 50% off that lease rate, right? So what we were able to do is show, hey, this park owner has discretion in this situation to either do or not do a new lease. And so we were able to go to the jury and say, hey, was this park owner reasonable in exercising that discretion under the contract? And the jury came back and said, no, they were not reasonable. And so we got that, and part of our verdict was based upon that principle. So if you have a lease that gives open-ended abilities for rent increases, you can make the argument that there has to be some sort of reasonableness under the good faith and fair dealing. The counter to that is good faith and fair dealing is an implied duty, which means if there's nothing specifically on it in the contract that says it's going to go one way or another. So for example, if it said every single time you sell your home, you have to keep your lease, your high lease rate, then you sign that, you're bound by it. It has to be discretion. The park owner has to give itself discretion in the lease in order to use that theory of law. And typically most leases don't provide a lot of discretion, right? You get this lease that's boilerplate, and it basically is 10,000 ways that you can get screwed, you know? Right? And so the park owners, so it's very difficult for us as lawyers to go in and find those little areas where there's discretion, where we can apply the good faith and fair dealing principle. What happens is, in a situation where there's these long boilerplate leases and there's really no wiggle room, no discretion, then in order for us to prevail on your behalf on a situation where you're being charged unreasonable rents or unreasonable leasing practices, we have to prove unconscionability. Does anybody know what unconscionability is?
Yes, in there.
So, unconscionability is a difficult standard. You have to prove, one, it's procedurally unconscionable. You were given a take it or leave it lease. You didn't have an ability to negotiate, and there were things in there that surprised you. Like there's hidden language, right?
Yes.
That you didn't know. Because otherwise, the courts are going to say, look, if you signed a deal, if you agreed to get screwed by the park owner, we're not going to do anything for you, right? So unconscionability is very hard. You have to prove that somehow they tricked you, and then you have to prove procedural, how they did it, and then what they did. Substantive, you got to show that it's so grossly unfair. There's no legitimate business purpose for what they're doing. And so it's a hard standard. And ironically, in Terrace View, we went to the judge beforehand to say, hey, judge, these leases are unconscionable. they have this catch-up provision. So they don't tell people what the highest three rents are. So they hide that. And they have this complicated formula. It wasn't just CPI, it was CPI plus some, it was plus 4%, and then it had three different versions of how you would calculate CPI. And so we took their VP depot and said, hey, can you explain how this works? And they couldn't. So that helped us quite a bit. But we go to the judge and we're like, look, this thing is procedurally unconscionable. These people don't know what they're signing. This is, they're not telling people what the three highest rents are. And it's substantively unconscionable because these rents are escalating. You got people that are literally having to move out because they can't afford these rents. And so the judge said, you know what, it's not procedurally unconscionable because the state of California has a law that says a park owner has to offer a month-to-month lease that's similar to these to certain terms. And there was a case out there that was a bad case, and so the court said, no, it's not unconscionable. So we're like, oh, great. So then that's when we're scrambling to find these little provisions where there's discretion so we can go to the jury on good faith and fair dealing and not get flushed out. So we ultimately win on that, as I said. We got the $60 million. And then the judge, after we get our verdict, says, you know what, I thought about that unconscionability thing. And after hearing everybody, right, after hearing people testify in my courtroom, because he ruled before just upon papers. We were just saying, hey, this is what's happening. He didn't actually have residents up there on the stand talking about what they were going through. He listened to what they went through and listened to how this park owner did this. He said, hey, I changed my mind on that unconscionability thing. And he gave us a ruling that said, this, and this is a Tatum and Kaplan Park, which is very similar to Court and Scott, very similar operators. And he said, these provisions in all of their leases throughout the state of California are unconscionable, and I prohibit them from enforcing them or offering them in any new leases. Wow. And so now the Tatum and Kaplan, the partner, is like, whoa, wait a second. We can just tell people what the three highest rents are, which they said before they couldn't do. So now we're fighting over that.
So in Court and Scott leases, what do you think about those leases?
I think they're horrible.
Same as.
I think Court and Scott are worse than Tatum and Kaplan, quite frankly.
So if you had their lease in a court of law.
Yeah, we had their lease in a court of law on a case called Hollydale, and we just had a really bad judge. We had a judge that no other judges liked, no lawyers liked, and he just looked at us, he looked at the residents with disdain, kind of like, and so it was just a bad situation. But I went through that lease, and I think it's worse than Tatum and Kaplan in some ways. It has a catch-up provision that says after the first 3 years, the rent will adjust to an average rent for a two-bedroom condo within 60 mile or within 60 blocks of the park.
Wow.
And so people are just getting hoodwinked. So that's so I talked about some of the items that we look for. When we go after a park owner, we go for, like I said, overpayment of rent. So if you're paying for rent, you're not getting the services or the park isn't being maintained. We get diminution in value. So if a park isn't maintained and the values drop, or if there's leasing practices that are predatory and nobody wants to buy in the park and the values go down, we go in and we have appraisers that get that value for residents. And then we get punitive damages. And we also get injunctions for things to be fixed. So, for example, they'd have to dig up that line you're talking about and replace it as opposed to just, removing the clog every time it happens. Yes?
I have a question. In Mountain View here in Nevada, a lot of the people have a 20-year lease, okay? And some of the people still might have like eight years left on the lease. ELS, what they're doing is they are saying that we are going to have increases once a year versus say I came in December, so my lease ends in December, but it ends in December, unfortunately now, this year. and other people might be ending in 2020. What they're doing is saying, what, July 1st, Michael? July 1st will be any increases. And we want you to come into the office and sign a new lease. Now, I saw the new lease, and it's a month-to-month lease.
Right.
So if you have a 20-year lease and it's still valid,
Yeah.
that is still valid, is that correct?
Yes.
Okay,
Yeah, it's still valid. You don't have to sign it.
right.
You don't have to sign the month to month. So, and we don't practice in Arizona, so I don't want to look at what you have. But under the facts you just laid out, yeah, I would just stick to my 20 years.
Yeah.
Nevada.
You're in Nevada.
Yeah, because what happened, this was not with ELS, but our predecessors, Hometown America, what they did is they had a meeting and where they wanted to offer everybody a 5-year lease. And, you know, you relinquish your 20-year lease.
Don't, I'm gonna,
Oh,
I'm getting to lunch, and if I
Okay,
keep people past
sorry.
lunch,
Okay.
it doesn't go well, right? Or hungry.
No.
These guys are sick of hearing about ELS parks. It's just, we keep going back to ELS. They're pretty unique, so that's why we keep doing it. So, real quick, so in terms of the damages, if you want to collect against your damages, if you want to collect damages, typically park owners have insurance that we collect against. If not, then we've actually gone after the park owners themselves and pierced the corporate veil. A lot of them will own the parks in trusts or in limited partnerships or corporations, and so we've been able to actually go and get to their personal assets. And the way you do that is it's called piercing the corporate veil. And so if you have a park owner that sets up a park, doesn't properly capitalize it, put enough money in to run it, that's one factor. The next factor is if they commingle. So for example, if you have a park owner that sets up a corporation, then personally you've taken your rent check to them personally, which quite frankly we're seeing less of. Now it's going to this corporate model, you're seeing less and less of that, but it used to be the mom and pops, and so they would basically just run the parks and get the rent. And then if they essentially what the court's going to look at is if someone has set up a corporation to run a mobile home park specifically to avoid liability, and they're not really conforming to the corporate formalities, having the corporate meetings, having the minutes, and so then we can get to the park owners' assets, and we have. And we've also followed park owners into bankruptcy and hammered them in bankruptcy and taken their assets, which they threaten us and say, we're going to file bankruptcy. We're like, great. File bankruptcy, because then a judge is going to have control of all of your assets, and we don't have to chase you around. So that's how we collect. So really, I'm going to close on just the steps that are key. And everyone's been touching on it before me, but protective laws are the key. You know, give lawyers like us, or give the attorney generals, get them the laws. At the state level, for us, the local level for us, really the rent control. If you can band together, and that gets to your question about the state level, and also on closure laws. In California, each local jurisdiction sets forth the closure laws. If the park owner wants to close a park, what they have to pay in relocation benefits. So get to your local jurisdiction before a park closes, because once a park is going to close, then it's a battle. So if you can look at some of the closure laws in California, if your jurisdiction doesn't have a closure law, ultimately you're going to end up potentially dealing with it. So if you can get a law that requires a park owner to do an impact report to look at how the closure is going to impact everybody and pay fair value for everybody's homes, that's kind of the home run. So if you don't have that in your local jurisdiction or in your state jurisdiction, then you probably want to focus on that proactively as opposed to after a park owner's trying to close a park. At the state level, again, get that failure to maintain law in there. You know, park owner doesn't just have to keep a park habitable; they have to provide and maintain all the facilities in a good operating condition. And if you can get the requirement for reasonable rent, like Florida has, or what Delaware has with a specific CPI increase, that would be great. And then prevailing party attorney's fees. It helps to bring in someone like me to help you with the laws, if the park owner is violating the laws, for me to be able to get attorney's fees against the park owner. Because we don't, by the way, we don't charge residents. We don't charge hourly. We do everything on a contingency. So we don't come to you and say, hey, give us all this money and pay us hourly and we're going to do this for you. We say, don't pay us a dime. In fact, we put up the costs. We pay the costs. And so when we take a case, we have to put everything into it. And so for us to have those attorney's fees that we can recover against is important. And the power in numbers, just organize, get together. So it is noon and I am done. Thank you very much.